Okay, we are now live. We are now live, right? Who's Tyler? We should be live.
Audio now?
I think your audio is actually live right now.
Okay.
So you do have audio. For some reason, the camera up there isn't working, but we've got an iPhone, which is the backup of everything, I guess.
Okay.
All right, well, thank you all for bearing with us for a moment. It all worked an hour and a half ago, so I don't know. All right, so today it's my great delight to welcome Dan Matheson. So Dan Matheson is the director of the Sport and Recreation Management Program at the University of Iowa. Prior to joining the Iowa faculty, he worked as an NCAA Associate Director of Enforcement and as the New York Yankees Director of Baseball Operations. And did you bring your rings?
Just one.
He just brought one of his rings with him today. Okay. He's frequently asked to provide expert insights during media coverage of sport industry issues. I've seen him on like ESPN sometimes and many other sources, including ESPN's Outside the Lines, the New York Times, and SiriusXM's College Sports Nation. In his teaching and other service to the campus, Dan prioritizes connecting students with employers to network and get hands-on experience with real projects wherever possible. And I've seen firsthand how hard he works on behalf of students to build those connections. Through collaboration with the College of Liberal Arts and Sciences, Dan's developed a national interdisciplinary first-of-its-kind student sports law competition as well, the College Athletics Infractions Hearing Competition. This event gives students roles as NCAA enforcement staff and University Defense Counsel, and the University of Iowa group recently presented their cases to a panel of judges across the country during mock hearings at the end of February. Now, are you going to talk a little bit about that?
I will if anybody has questions.
All right. If anyone has any questions. So Dan's going to talk for about 50 minutes, about 40 to 50 minutes, and then we'll have a little bit of time for questions. So just give me a moment to get back up there, okay. And let's welcome Dan Matheson.
Thanks, Professor Rantanen. I'll give him a moment to get set up. Will you give me a thumbs up at some point? Oh, good to go. All right. Well, thank you all for being here today. It really, I will save time for questions and look forward to continuing this discussion that has been going on all semester in this speaker series that Professor Rantanen has put together. I'm really excited to keep the discussion going around this topic of name, image, and likeness. And so I'm going to start with a story and stop me if you've heard this one before. A skier, a kicker, and an avatar walk into a bar together. I can tell that you know where I'm going with this one. Just kidding. My inspiration for the title of my presentation today was I gotta get my clicker. My title was inspired not just to grab your attention and try to get you curious about what I was going to talk about today, but also was inspired by what I would argue is the path that led the NCAA into the name, image, and likeness era that we are in now. And that path was cut by the skier, Jeremy Bloom, the kicker, Donald De La Haye, and Ed O'Bannon, or more specifically his avatar that appeared in the NCAA basketball video game. And California in 2019, as many of you know, passed legislation that made it legal to give student athletes name, image, and likeness monetization rights in the state of California. Many states followed California's lead and eventually in 2021 forced the NCAA to lift their century-old ban on student-athlete name, image, and likeness rights. But what got elected officials to that point? And I'm intrigued by the question of how did state legislators, who these days can't seem to agree on anything across party aisles, all come together in this moment of harmony to agree to do battle against the NCAA over this issue. I would argue that that the answer to that question lies in the case study of the skier, the kicker, and the avatar, and the 20 years of momentum that was building up to 2019, when the California legislature felt it was important enough to step in and create new law in this space that pushed the NCAA to finally start to modernize its amateurism rules. So we're going to look at those issues. We're going to talk about what occurred over the 20 years of these three individuals and the NIL test cases that they presented to the NCAA, and how the NCAA responded and the strategy, the approach that they took in responding to each of these individuals and their cases, and where that put them in 2019 and where they are now. We'll also talk about what's next in the NIL space, what to watch for, and maybe some thoughts that I have about the direction that the NCAA should go in with some of its new challenges that it's facing in the amateurism space. We'll get to all of that, but before we do, I want to take just a moment to spend a little time establishing some base level name, image, and likeness knowledge in the room. I don't want to assume that everybody in here reads about and thinks about NIL as much as a sports law nerd like me. So just to begin with, NIL, when we talk about NIL, we're talking about publicity rights for college student athletes. In some states, high school athletes also have name, image, and likeness rights. But it's the ability to monetize those publicity rights while maintaining their eligibility for college athletics. When we say that a student athlete has an NIL deal, we're saying that they've monetized their publicity rights in some way, like doing an autograph signing in exchange for compensation, doing a commercial, or what is most common in the NIL space, doing paid social media posts, which is a part of the majority of name, image, and likeness deals that student athletes are signing. Name, image, and likeness is a big deal because for more than a century, the NCAA forbid student athletes from being able to monetize their publicity rights. And if we learned anything at the end of the first year of NIL, it's that student athletes have left billions upon billions of dollars on the table over the decades that they were prohibited from accepting compensation for their valuable NIL rights. So there's one other area that I want to talk about is a little bit of background for those of you that don't follow NIL that closely, and that's the idea of collectives. The University of Iowa has a collective called the Swarm Collective. Collective, as it relates to the NIL space, is anytime individuals or businesses pool their resources in order to create essentially greater buying power in the NIL marketplace. collectives, while they present themselves as being affiliated in some way, or at least supportive in some way, like the Swarm being an Iowa collective and other collectives that are affiliated with or appear to be affiliated with schools, collectives cannot be run by schools or athletics departments. There has to be an arm's length relationship between the two. Although there's lots of speculation that some schools are too closely entwined with their collectives, and we'll talk a little more about that later. Despite the fact that collectives cannot be part of the athletics department, and the athletics department can't prop up a collective on its own, if in the current NIL space, if your school doesn't have an aggressive collective supporting your recruiting and student athlete retention efforts, your school is considered to be behind the times and at a competitive disadvantage when it comes to recruiting, which is the lifeblood of athletics, and retaining student athletes. And there are different ways that collectives can be formed. The Swarm is one example of a subscription membership model, same as the Volunteer Club here, which supports the University of Tennessee student athletes. Collectives, this is a common form of collective. They've got their membership posted prominently there on their home website. And so just like you pay a monthly Netflix subscription, you can pay monthly into a collective so that your subscription fees are funneled towards NIL deals for, in this case, Tennessee Volunteer student athletes. And these collectives exist, I said, to give greater buying power in the marketplace. These collectives exist, generally speaking, to support recruiting and retention of student athletes once they've started at school. And there's no better example of that than the collective at Texas A&M, the Matador Club. Last summer, the Matador Club boldly proclaimed, we're giving a $25,000 base salary to every member of the football team, basically. That's the type of behavior by collectives that is being criticized nationally, that has many in college athletics screaming for the NCAA to crack down on perceived misuses of name, image, and likeness. There's a common belief in college athletics and in higher ed overall that NIL provides a lot of potential benefits for student athletes to be able to go out and legitimately be entrepreneurial, sign deals for themselves, but nobody anticipated the collectives when NIL started, and they quickly filled the NIL space and have become a significant player in name, image, and likeness transactions. And they're engaging in things that are not what members of the NCAA, meaning schools, athletics directors, conference commissioners, want or believe name, image, and likeness should be about. So little bit of background on name, image, and likeness and some important issues of the day before we circle back now to the first of the three NIL test cases that I want to talk about today as we go back about 20 years to 2002 when Jeremy Bloom was a star football player at the University of Colorado. But he was a very unique two-sport athlete in that he was also an Olympic-level skier. We haven't seen a two-sport athlete like that, and that presented a unique NIL challenge to the NCAA, and nobody was even using the expression NIL back then. He was interested in having the right to monetize himself for endorsement purposes. The issue, the challenge here for the NCAA for a dual sport athlete like Jeremy Bloom is that they have rules that do allow you to be an amateur college athlete in one sport and a professional athlete in a different sport. And a common example of that in college sports is college football or basketball student athlete who plays minor league summer professional baseball and is paid a salary for playing baseball from their baseball team, but can go back to school in the fall and play football or basketball. The issue with a skier like Jeremy Bloom is that skiers don't receive much in the way of prize money. They don't have a standard salary like a baseball player does playing minor league baseball in the summer. They derive the majority of their income from endorsements. And Jeremy Bloom had already been on the U.S. Olympic team in 2002, and then he was a freshman football player at Colorado shortly after. And in order to get ready for the next Olympics, he wanted to start accepting endorsement money. His argument was that skiers, since we rely on endorsements in order to train and travel and compete to get ready for world competition, I can only do that if I can accept endorsement money. Unfortunately, at the time, the NCAA rules prohibited any form of endorsements, even if you were a professional in one sport. So even if you played minor league baseball in the summer and came back to play football in the fall for your school, you couldn't accept endorsement revenue. So that was an obstacle, but the NCAA has a waiver process. And we're getting to a crossroads moment for the NCAA here. This was a very high-profile case as it was unfolding in the early 2000s. And the NCAA has a waiver process that you can follow if a school believes that a rule should not be applied to a student athlete for a certain reason. And so the University of Colorado applied for a waiver and asked the NCAA to not apply its traditional endorsement restrictions to Jeremy Bloom, allow him to accept endorsements related to skiing while keeping his football eligibility. His initial waiver was denied, and the NCAA has an appeals process, and his appeal of that waiver denial was also denied. The NCAA, this is that crossroads moment that the NCAA was faced with. They applied a very strict reading of the rules, and the NCAA's position at the time was that this would create a slippery slope. If we allow an exception in this case, what'll be next? What sort of creative end around to get through the rules will the next student athlete offer us? And so the NCAA didn't want to start down that slope. They also, the NCAA argued that, look, on that previous slide, when you see Jeremy Bloom in Tommy Hilfiger trunks, we don't know if that Tommy Hilfiger money is being given to him because he's a skier, because he's a football player, because he's a unique dual sport athlete, or just because he's a handsome guy. We don't know. We can't, since we can't discern what's related to football and what's not, then we're just not going to allow you to do it at all. And so he was left with the decision: do I continue to play football or do I give it up in order to continue my skiing? I want to do both. And all the while, the public and college sports public and those beyond college sports followers were watching this unfold. And Jeremy Bloom was not content with the NCAA's decision. He chose to sue the NCAA in Colorado State Court. He was asking for injunctive relief so that he would be able to participate in football in the 2004 fall season. And the NCAA sought to defend the ability to apply its rules as it saw fit and to protect its version of amateurism. The Colorado State courts sided with the NCAA at trial and on appeal. The court said that the NCAA was not enforcing its rules in any sort of arbitrary manner. They were applying their endorsement rules to Jeremy Bloom the same as they do to all student athletes. And this endorsement prohibition seems to have a rational relationship to the NCAA's stated goal of keeping college sports separate from professional sports. So this was, as I've been building up to, the first of three crossroads that the NCAA came to on its path to name, image, and likeness. Jeremy Bloom caused the public to think, many people in the public to think for the first time about, are these rules fair? Does this make sense? And I want you to think back to 2004 when this decision came down. And at the time, we had professional athletes participating for the first time in the Olympics within about the past decade. We had the NBA Dream Team in 1992. The Olympics had forever been reserved for amateur athletes, and so there was a growing belief among the public and the sports community that what's the problem, or why is there a problem with an athlete who receives some endorsement money participating in what's previously been thought of as amateur sports or college sports. Another issue that raised some of the questions, I'd say, in the minds of the public, or at least planted the seed for what was to come, was the idea that the NCAA had become much more professionalized in its marketing of its football and basketball product, and so there was less support or eroding support for the idea that student athletes must not receive any sort of compensation outside of their playing football. And also, not insignificant in the public's perception of Jeremy Bloom's case was the 15 to 20 years or so leading up to his case, where NCAA revenues and coaching salaries had really started to reach a level that no longer resembled anything having to do with higher education. By the time Jeremy Bloom's case came about, the highest revenue athletics department was bringing in over $100 million a year, and the average salary for a football head coach was approaching $1 million a year at this point in time. And so these were all issues that when the NCAA dug in its heels and fought back against Jeremy Bloom and his effort to ask the NCAA to think progressively about amateurism, that caused the public to question, what are we supporting here? Does this make sense? And what direction is college sports heading in here when this young man can't take advantage of these opportunities? So that's test case number one. I want to talk about Ed O'Bannon, and you can see here on the screen Ed O'Bannon on the left as he looked three-dimensionally in real life, and Ed O'Bannon on the right as his avatar appeared in a video game. Ed O'Bannon became the named plaintiff in a class action lawsuit against the NCAA that continued this national discussion about name, image, and likeness rights. And the O'Bannon case was where college sports started to, where you actually started to hear NIL being thrown about. Ed O'Bannon, while he was a superstar college player, never really achieved what was expected of him professionally, and therefore about 10 to 12 years after his professional career ended, he was selling cars in Las Vegas. Not that there's anything wrong with selling cars in Las Vegas, but it certainly wasn't the trajectory that he was on as he graduated from college, and the expectations were that he would be a longtime NBA All-Star. So Ed O'Bannon became the face of the first antitrust lawsuit challenging the NCAA's amateurism rules. Ed O'Bannon represented the class of football and basketball student athletes that were suing the NCAA as well as their licensing company, CLC, and eventually EA Sports, that was the producers of the very popular NCAA football and basketball games, were joined as a defendant. The issue here, as you can see from that avatar and Ed O'Bannon's avatar on the previous screen, was that the NCAA licensed its valuable brand assets to EA Sports. The logos, the colors, even the uniform numbers, all for EA Sports to create this very lifelike game that really captured the physical characteristics and mannerisms of players on court or on the field. The problem was the NCAA, EA Sports in their game never used player names. And the NCAA specifically, strategically withheld player names from the video games. And at that point in time in the history of the NCAA, student athletes, when they became a student athlete, had to sign a release that gave up their rights to their name, image, and likeness while they were a student athlete and beyond. So Ed O'Bannon, when he's being depicted in an NCAA video game 12 years after he graduated, and by that time he's selling cars and he's not getting the NBA paychecks anymore, he's realizing, wait a second, somebody's making money off of this and it sure isn't me. So that he became a very sympathetic lead plaintiff in this case, and a great vehicle for telling this story of why the plaintiffs were suing the NCAA here, asking for NIL rights. So as that case progressed, the EA Sports and CLC, they got themselves out of this case before going to trial. They settled. Actually, a lot of student athletes from that era received paychecks from EA and the EA and CLC settlement. They discontinued the video game, much to the chagrin of probably some of you in here, and I know I've heard that complaint before. But the NCAA, again, in another Crossroads moment, said, no, we're going to trial. We're going to defend against this unjust uprising by student athletes. So this case was heard in the Northern District of California, which Judge Claudia Wilkins' courtroom has become considered by many to be home court advantage for plaintiffs in these cases against the NCAA, starting with this O'Bannon case. Judge Wilkin agreed with the plaintiffs that the NCAA was violating antitrust law in the use of its amateurism rules to keep student athletes from ever receiving any compensation for their name, image, and likeness. And she found that there would be two less restrictive alternatives that to their traditional amateurism rules that would help bring the NCAA into compliance. The first of those being to allow schools to provide full cost of attendance scholarships. And that led to stipend checks for student athletes of usually about between $3,000 and $6,000, depending on the school you were at, to cover the full cost of attendance beyond what tuition, room, board, and books cost. So that was viewed as still being educational expenses, but a scholarship should be allowed to cover that. The second, less restrictive alternative to the amateurism rules in Judge Wilkin's eyes was $5,000 a year that each school should have to set aside for its football and basketball student athletes that they would receive upon graduation as a compensation for the use of their NIL in broadcasts, in video games, or in other such endeavors. Not surprisingly, the decision was appealed, and in the Ninth Circuit upheld Judge Wilkin's first less restrictive alternative and said, yes, we agree. Full cost of attendance scholarships make perfect sense. We do agree with Judge Wilkin that the NCAA is violating antitrust law, but full cost of attendance scholarships are all that's needed. The Ninth Circuit disagreed with Judge Wilkin's $5,000 a year trust fund to be created and bestowed upon graduation. And the Ninth Circuit, I highlighted this language because this became language that the NCAA really latched onto. Despite losing this case, the NCAA said, but look, they defended our belief about amateurism by saying that cash sums untethered to educational expenses would be a quantum leap that we are not going to take in the Ninth Circuit. The NCAA saw that as a small victory within a larger loss of decision. Now that language, I highlight that, and I want to go back real quickly before we go forward. And I want to take you back briefly to a Supreme Court case in 1984, because there was other important language that the NCAA was relying on here to believe that the judicial system supported its version of amateurism. In the Board of Regents case that went to the U.S. Supreme Court and was not about amateurism at all, it was about the NCAA's strict control over broadcasting football games, the court said, most significantly highlighted there, in order to preserve the character and quality of the college sports product, athletes must not be paid. Between that and in 1984 and the Ninth Circuit, in many ways reaffirming that position by the Supreme Court in 2015 in the O'Bannon decision, the NCAA was emboldened to continue to defend its version of its version of amateurism, and believe that it still had solid ground from which to enforce its amateurism rules without interference by the courts. And that was, that's really this second crossroads moment that the NCAA came to along its journey to name, image, and likeness where we are now. The Jeremy Bloom case was decided in 2004. The O'Bannon case gets filed just 5 years later, takes 6 years to be litigated, And so you're talking about a 11, 12-year period where name, image, and likeness is really becoming part of the national discussion. And sports fans, media commentators, and people that worked and lived within the college sports space had a growing awareness of some potential issues of unfairness in the NCAA rules and the way amateurism had always been applied. And I would also argue that the O'Bannon case at least helped spawn a couple of other cases. Many of you have probably heard about the Alston case that did end up going to the Supreme Court back in 2021. And that was another antitrust challenge to the NCAA's amateurism principles that went beyond just name, image, and likeness. That case was filed after the O'Bannon case, and Northwestern's football student athletes made an attempt after the O'Bannon case was filed to challenge the notion that they could not be employees of their institution using the National Labor Relations Act. So I would argue that were it not for the O'Bannon case being filed and those plaintiffs having some early success, not getting their case dismissed in the early stages of litigation, that it encouraged other potential plaintiffs to come forward. So we've come to two crossroads, and there's one more to go, and that is the kicker, Donald De La Haye. Donald De La Haye was a kicker at University of Central Florida, but he was also a budding YouTube content creator. He had a YouTube channel that had both non-football and football videos, and he was monetizing his channel through the advertising and subscription numbers that he was running. And that created another Jeremy Bloom-esque issue for the NCAA to deal with. And the University of Central Florida, just like Colorado, applied for a waiver of the usual policies. And the NCAA in this case granted a limited waiver to Donald De La Haye. They said, you can keep your YouTube channel up and still play college football, but you can't monetize football videos on your platform anymore. And that presented De La Haye with a crossroads moment of his own, and he decided he was unwilling to accept that compromise. He gave up his scholarship, gave up his football career in order to pursue what was becoming a lucrative YouTube career. This again, in terms of keeping the issue of name, image, and likeness and fairness of some of the NCAA rules and how they're applied, kept it front of mind for many in the world of sports. And this was in 2017, Donald De La Haye's case was being dealt with, again, just 2 years after the O'Bannon case had been decided. So we're towards the end of this 15 to 20 year period of time where the public is really starting to question, what's the NCAA doing here? And does this make sense? Can we support this any further? And that's where just 2 years after Donald De La Haye, you see California legislators step in and say, we don't see the courts able to resolve this to our satisfaction. We need to step in and create new law. And California led the way, created the Fair Pay to Play Act that basically prevented the NCAA from being able to enforce its name, image, and likeness restrictions on athletes at California schools. And I've been talking about each of these NIL test cases that the NCAA faced along the way. building up growing frustration. And when you read California Senator Nancy Skinner's comments here, she was a co-author of this legislation, you can see and feel the frustration, I'm sure, in the constituents that she talked with, in everything that she learned as she was researching and writing this piece of legislation. She reflects where society was at the point in time that California was ready to step in and force the NCAA to modernize its amateurism rules. So I want to transition out of the historical context into a little bit of discussion of what's coming in name, image, and likeness, what to be on the lookout for as we go forward, and some thoughts about what's coming next for the NCAA in terms of its next big legal challenge to amateurism. One area that I would encourage you to monitor and keep an eye on is enforcement. We are now almost 2 years into the NIL era, and there's essentially been no infractions cases involving name, image, and likeness. However, there have been dozens upon dozens of popular media stories about situations that on their face really look like violations of NCAA rules involving name, image, and likeness. So there's growing a cry that's coming out among those in college athletics for the NCAA to start enforcing rules. I have the Cavender twins up there because, yes, there has been one infractions case involving the Cavender twins at Miami, and it's NIL related, but it really isn't the bombshell NIL case that everybody's waiting for. It's really just about a coach introducing them to